how would you describe your judicial philosophy, especially in cases involving constitutional limits, separation of powers, and taxpayer issues?
Sure. Well, my judicial philosophy, I think, is pretty straightforward. The role of a judge is to interpret the law as written and in accordance with the language of the Constitution as written, not to inject policy preferences and to reason backwards from a desired outcome. I say, that's exactly how my as an attorney, you can't inject your policy views. I have to advise my clients on this is what the law is. When there are areas where either the law exceeds constitutional authority, when a rule exceeds statutory authority, or when there's a dispute with the state over those things, that's when the part of my practice gets into controversy work, which leads to cases before the state Supreme Court. That's an area where the court only takes cases on a discretionary basis, and one of the criteria is whether it's a matter of substantial public importance. One of the reasons why I've handled so many state Supreme Court cases because taxes tend to be a matter of substantial public importance, and making sure that the government follows the law as written and within the constraints of the Constitution is the fundamental role of the court within our system of government, which has three co-equal branches and a system of checks and balances. And the court's role is to serve as that check and balance against legislative and executive overreach, not to be an additional legislature or an additional executive.
So, Justice Colleen Medley, she was recently appointed by Governor Bob Ferguson after working under him in the state attorney general's office. She's also received campaign donations from people inside the AGO, endorsements from people inside the AGO, and ultimately the AGO is going to be the party defending the income tax should it reach the state Supreme Court. I was wondering what concerns, if any, should voters have about that appointment and Justice Medley's background?
So, well, the history of our state constitution, when we were a territory, judges were appointed by the territorial governor. One of the concerns people had with that at the time that we became of statehood is the concern that judges appointed by the executive will carry out the desires of the executive. And that's a reason why Washington's Constitution provides for judges to be elected by the people, not to be appointed by the executive. And one of the reasons that I'm running is because there's developed a pattern in Washington state where sitting judges will retire before the end of their term, the term that the people elected them to, in order to allow the governor to appoint their successor and for that person to run as an incumbent. Frequently in that first time around, and also in subsequent times, they draw no challenger. And that undermines the whole process and takes away the people's right to vote for their judges. That's one of the reasons why I'm running for the Supreme Court, to give people a choice. And I'm running to restore independence, to focus on a principled analysis and the rule of law. And like we've talked about, interpreting statutes in the Constitution as written, not from a policy perspective.
Mhm. In a lot of candidates on both sides have pushed in their TVW voter guide statements that they want judicial independence. You're arguing that the appointment process undermines that. I'm wondering, do you see the state Supreme Court as already being a partisan judiciary?
So, well, the state Supreme Court, as it's currently comprised, is recognized nationally as one of the most activist, progressive Supreme Courts in the country. They haven't shied away from injecting their own policy preferences into Supreme Court decisions instead of interpreting the statutes and the Constitution as written. Again, that's exactly why I'm running for Supreme Court, is to get away from that policy focused decision making and get us back to a focus on the rule of law. Uh, you know, One of the things that was interesting to me as I was trying to craft my voter statement, which is limited to 200 words, is I think that the words fair and independent are words that you will probably see in all 16 voter statements.
Mhm.
I think how those words are intended to be conveyed by different candidates vary quite a bit. And I think one of the things that probably sets me apart from most of the 16, certainly not all, but many of the 16 people who are running, is to be clear about what I mean by that. And that is to focus on statutes and the Constitution as written, and not to bring a policy bent and read either into or out of things that aren't there.
Mhm. So, given some of the concerns around Melody's appointment that we just talked about, what do you think the line is between like normal legal and government experience and an appearance of fairness issue that might require a justice to step aside on a case?
So, well, the question of recusal, I think, is a issue that arises in the context of a specific case that would come before the court. I think the question of of choosing a candidate for that position is a broader and different question, and appointing as your it's hard to say that the governor's first appointment to the Supreme Court, because the governor shouldn't be making any appointments to the Supreme Court, but when the governor makes an appointment to the Supreme Court of a person who, for most of their career, has been the governor's top policy executor when the governor was the attorney general, I think calls into question the notion of independence.
Hmm.
It really goes to the heart of the concern within the Constitution of rejecting the notion of the governor appointing judges, and at the very least there's the appearance that and the suspicion that somebody whose career has been serving a particular individual, when that individual appoints them to office, that they will continue to have that focus in the performance of their office.
And given what you just said, in the fact that she had worked under Ferguson, Ferguson signed the income tax. There's emails between Senator Peterson, who wrote the income tax, and the AGO, on trying to get the matter to the court to overturn prior precedent. Do you think that Justice Medley should recuse herself should the income tax issue reach the Supreme Court?
Yeah, that's a debate that is premature, that I don't want to weigh into.
Hmm.
And the reality is you're going to hear from other people that my experience as a tax attorney,
Hmm.
and particularly my experience challenging the capital gains tax, would be cause for me to recuse myself. I think the arguments for with respect to either of us in that regard are premature and would need to be dealt with, if and when that's something that comes before the court.
And along the same line, is that an issue that you would have to actively consider in the future if elected?
Oh, it certainly is an issue. I think the analysis is different because typically the question is whether the attorney or the attorney's firm has represented is representing a party to the litigation.
Hmm.
I one of my former partners, was elected to the Thurston County Superior Court a number of years ago, and I had numerous conversations with him as he was trying to navigate and understand that issue, and ultimately, one of the things that he decided that during at a minimum his first year on the bench as a trial court judge, he would recuse himself from any matter in which any attorney at the firm was representing a party without regard to whether he knew anything at all about that representation.
So a lot of voters are going to be looking at the Quinn ruling as we head into this election, given the political climate and the issues that could be heading to the court in the next year or so. You helped litigate that case. Um, what should voters be looking at on that ruling as they consider who to vote for in this election?
Yeah, I don't know that looking at past rulings will help voters to decide who they should vote for in the election. And I'm not sure, I'd be skeptical as to whether the Quinn case would be a significant case impacting the analysis and ruling in a challenge to the income tax. The ultimate ruling in the Quinn case is that the capital gains tax is an excise tax imposed on the activity that gives rise to the gain rather than on the income received. Uh, there's not a similar type of structure in the income tax, so I don't anticipate there being any likelihood that anybody's going to argue that the income tax is actually an excise tax. So in that regard, I'm not sure that Quinn is going to be particularly meaningful one way or the other in that litigation.